Hello, good morning, good afternoon. I'm really excited. It's been kind of iffy with these Courtney Clenney hearings, and not just if things are going to happen as scheduled or if they're going to get continued again, but also there hasn't always been a media pool going in and getting the footage. And last night, Law and Crime uploaded this hearing clip. It was short, it's like 21 minutes, but I'm really excited to just kind of get a feel for what's going on. I feel like we don't get in the courtroom all that much. So this is going to be a blind watch for me, although I had looked at the docket. You may have seen the update from me. I do know some of the outcomes, right? So Judge Wolfson is going to reserve ruling on Clenney's motion for a bill of particulars. That means that the state still needs to define, particularly on the count 2, the interception of wire communications, this month-long date range. What exactly are you alleging that Courtney Clenney did that was a crime? Because this is a broad date range, so how can she properly defend herself? So please provide us more specifics on that count. So Wolfson's reserving ruling on that. Wolfson's also reserving ruling on Clenney's motion to compel, which she filed yesterday. So we're going to hear about that, I think, in this discussion. And then the hearing for bond and the motion to dismiss are now set for December 18th. So that's a big one. I believe, I would say like 95% sure that we'll have a camera feed that day. So mark your calendars. We'll get together and watch that live. That's going to be a Thursday. And besides that, I've got the volume boosted. Got the volume boosted here. And again, since we are moving towards the trial phase, we do have the presiding judge, Andrea Ricker-Wolfson. Laura Sharon Cruz was the judge for all the, super early pretrial matters. So that's why we're seeing a different judge on the screen. And good morning to everybody. I see Gwyneth, Cryptician, who says, lucky it's a Saturday so I can catch this live. Always love to hear that. Mavka says, duck yeah. Heck yeah. Jay Money, good to see you. My friend Slim Life and Jay, good to see you. And Dream or Reality, good to see you. Good to see you. So this volume should be boosted, but if we need to make it louder, let me know. Because this courtroom and the acoustics, they don't play nice together. But we'll see. We'll try to hear the best we can. See?
No, Miss Gloss is not officially on.
And hold on. Slim Life, yes. So Courtney Clenney stabbed her boyfriend. But I don't want to get my years messed up because I want to say 2023, but I think it was 2024. January 2024, all of the fuss happens with the parents getting arrested. So Kim and Deborah Clenney, mom and dad, get arrested in the laptop case. And once they were doing the searches to prepare for those search warrants, around the same time period, they added a charge to Courtney Clenney's murder case. That was an interception of wire communications charge. I had not seen that count as part of the indictment previously. So, and all it says is the indictment is, I think it's like February 29th through like March 30th or something like that, is the time frame from 2022 where they think Courtney Clenney was either surreptitiously recording or doing something to intercept communications. It's a pretty broad statute, and the indictment, the count in the indictment does not define exactly what it is that they're saying she did, which is why she's asking the court to compel the state to provide a bill of particulars, because every defendant has the right to know what they're supposed to be defending against. So she still does have that count 1, which is going to be the murder, the second-degree murder with a deadly weapon. And that's that's not good in Florida, right? You get that with a deadly weapon, it's going to be the knife. Florida does not play lightly when the use of a deadly weapon is part of the charges. So that's the counts here. Also, Big Rice Street in here dropping 5 gifted memberships. Let's get some rice emojis going. Good to see you. Hope you are doing well. And I feel like I should clarify my stance. Sometimes I get comments and I'm not sure if it's people just expressing their own opinion, which is great. Please do that. Sometimes the comments are worded almost as if they're directed towards me, and nobody needs to have the same opinion as I do. I personally think Courtney Clenney has a huge uphill battle. I am not sure, even if she relies on a battered spouse defense, that she has a chance of, I would say maybe a hung jury But I still think there's a chance that she gets convicted, a very strong chance that she gets convicted of the second degree, not something lesser included. Um, and you never know. Like, jury trials can be unpredictable. But just so you guys know, I personally think that she will be found guilty, at least of something. Who knows, right? But I also think the state has messed up. I think the prosecution has colored outside the lines. They're the reason for this delay. So if you hear me complain about, what would someone that didn't have OnlyFans money do to defend themselves against charges like this? That's commentary on the state messing up, when really they had no reason. Just color between the lines. We could have had a trial already, and I really think the state could have gotten a conviction. But they wanted to snoop into things they shouldn't have been looking at, and here we are, waiting for a trial date. So there's my stance for anyone that's new here or, gets confused thinking that if I criticize the state that I think that she was an angel. I really don't. But thank you again to Big Rice Street, and good to see everybody piling in. We've got oh wow. We've got the Ice Street. Love to see it. Big Rice Street, that's right. And there you go. I love what Mavka's saying here. I don't have an opinion because I haven't seen the trial or evidence yet. I've got a ton of stuff linked in the description of this video if you want to deep dive into the journal notes, some other videos. That's really what's steering my opinion. Some trials that we watch on this channel, I don't know anything before gavel starts day one, right? So I'm watching almost as a backseat juror. But with the Courtney Clenney case, I've taken a deep dive into the evidence. Like, anything that was publicly available in Discovery, I've obtained, and like, we've done a ton of videos and streams looking at it. It's not clear if all of the stuff that we've been able to watch on this channel is going to be presented at trial and the jury is going to see it. So my stance, back of my mind, Courtney's own journal notes, her saying that she hits Christian to relieve tension. To me, if the jury gets any wind of that, you're going to have a really, really hard time, I would say, convincing jurors that, hey, you know what? She was actually acting in self-defense, even though there's tons of journal notes where she documents other incidents and at one point explains that her intent is not to get him away. Her intent is not to defend herself, or her intent is just really a reaction. She's describing it in those journal notes as intent to relieve tension and coaching herself in these notes about how that's not a great way to deal with her own anger. So that's shaping the opinion I hold when I speak with you guys. The jury might not know that. The jury might not get to see that. So always good to contextualize. This particular case I'm watching as a deep dive with a ton of information outside of what the trial might contain. So, and there we go. Yeah, so that's what I think. It's going to be very hard for Clenney to beat this. And not for nothing, I think anybody that's put on trial for murder, it's an uphill battle, because I really think jurors wonder, why would we be here if there wasn't good evidence for it? So with Big Rice Street sponsoring the stream and our volume boost here, let's see what happens at this hearing. Oh, they're having mic trouble, I think.
She was on the computer case that was an old process.
Yeah, okay, very good. All right, we're here now to address the state court versus Courtney Clenney. The president and assistant state on Adcock and attorney Frank Anthony Grego, as well as Ms. Clenney, who is present in court. And I'll turn it over to the defense.
Sure, Judge. Just to kind of update the court, we have pending a motion to dismiss. We have pending a motion for reconsideration of bond, which we filed a second amended motion recently. We have a motion for bill of particulars as to count 2 of the information. We have a motion to suppress surreptitious recordings. We have a motion to compel 404 evidence, and we have a motion concerning the CGI that was awarded.
All right, so that's the motion to compel is what they filed this morning. So I think everything else they've discussed, if you go through the playlist, you'll see like a stream where we cover the motions, including like her most recent amended request for bond. But a motion to compel 404. Now, I wonder if they're requesting, and I don't see that on the docket yet, but if I can grab it and we can look at it, we'll figure it out. But maybe there's concern from the defense that the state plans to introduce prior bad acts, bad character evidence about Courtney that they don't already know, which would mean stuff that I have not yet seen on the discovery list. Or maybe that's 404 evidence for a potential witness they plan to call. Because, you don't always get to blast a witness in a case, or maybe the victim, maybe Christian Obumseli. You don't just to throw out all their dirty laundry, but if there's something that would be necessary and probative, more probative than prejudicial, to get to a witness's bias or lien or character, sometimes that stuff would be admissible. So I'm excited to look for that and see exactly what they're asking for.
As of, no, you're good. As of this morning, the only one that has been responded to in writing, which was last night at, I think, roughly 7 p.m., was a response by the state, which I have not reviewed, to the motion to dismiss. All other motions have not been responded to in writing at all, and my communication attempts with the state have fell on deaf ears until yesterday. I had not heard from them in probably about 30 days, despite repeated emails. I know Mr. Abahoff was in definitely the case and then out. I do understand that, and out for the holidays. But we need some hard dates for them to respond. Again, I know it appears Mr. Abahoff may be in trial on Monday, depending on what the defendant ultimately decides, but as we used to be called, fungible to a certain extent. There's multiple state attorneys that are on this case, and we need to get it moving. And again, we've been asking for over 60 days. This is not subject to motion, but we've been asking for over 60 days, and it's gone unresponded to. If they can just please have their VICWIT update the addresses of all the civilian witnesses to make sure that, in moving forward and serving them for depositions, that we're not chasing, squirrels running around the country. So, again, Mr. Abahoff, last night, in his very professional response, indicated that he's aware that these things need to get responded to, and he's doing, I guess, his best efforts to make that happen. But at this point,
why they zoom in on the judge like that?
We're asking for some hard dates for the state to reply, and especially hearing date. I think the most paramount one in the defense's mind is the motion for reconsideration of bond. So I would ask, I'm asking for dates, response dates for all of these, but I would put that one in the forefront for him to have a sufficient amount of time to respond in writing and to set a hearing on that.
Okay. Is that it before I turn it over to the state? I
can't read my own handwriting,
yeah.
But let me get these out. Yeah, that's where we're at.
Okay. So one thing I want to ask for, I will just respond in whatever way you wish, is I would like to think the easier things first. To me, one of the easiest things Mr. Craig mentioned was the addresses of witnesses.
Yes,
What's the status of that?
So, Judge, I can tell you that the most that they've done is to try and make telephonic contact with them.
They being the victim witness.
My victim witness counselors. So, and I apologize because we need to do more than just that, obviously. So I made a note for myself. As soon as I go back today, that's the first thing I'm going to tell them to do, is confirm everybody's address one way or the other, just so that I can get that to them hopefully by Monday.
Well, and I'm going to put a deadline on that for the next Friday. So by next Friday the 12th, all listed witnesses, now certainly I know that discovery tends to be an evolving process, but if something new arises, then this wouldn't be
Shout out to Sheriff Chuck.
applicable. But any witnesses who are already on the witness list, you must provide updated addresses to the defense by Friday the 12th.
Yes, Judge.
At 5 p.m. Now, do you intend to file responses in writing to the other defense motions other than the motions to dismiss that you already filed?
Yes, Judge. So and not in any particular order, but I have, I guess, a request or a question for the defense. One of their motions is to admit a CGI video. I have not seen this video. I'm not sure if it's been created yet. It's hard for me to object to it or even have an opinion on it if I don't know what it is.
Okay, that's fair, Mr. Creator.
Sure, Judge, it's a kind of a preliminary motion in limine addressed more so to the court as to the admissibility. Ms. Puglisi was working on this, but we worked together, but it was more of a preliminary before we finalize anything with the CGI people. It's more of a base request with regard to the admissibility as a demonstrative aid versus evidence. It's not, obviously it's evidence-based, but it's
Your
really...
intention will be for it to be a demonstrative.
Correct.
Yeah, okay.
Right. Yeah, there's changes in how the law applies. I don't think it's admissible,
Yeah.
but it's definitely demonstrative. So it's kind of a pretrial. That's why we named it motion limiting. We don't have a video. It's not complete. They've been working on it, but we just before we go ahead and finalize the video, and obviously that's the court's ruling on this pending motion limiting could change depending on obviously the expert witness testimony that would be presented, but we want to have kind of a direction.
And yeah, good call here, Sabata. So for those with the recall coming back to you, the CGI video is the apartment recollection because they want to be able to demonstrate the series of events. They're arguing that it would be a demonstrative aid for Courtney Clenney when she's on the stand testifying. So big hint, or maybe they're just trying to tease and misdirect the state on their strategy. But that's a big hint that they're offering that Courtney Clenney will be taking the stand in her own defense. Likewise, if you guys missed it, she did file a notice of intent to rely on battered spouse syndrome. And again, that can be compelling. In fact, in her recent motion for bond reconsideration, she's making the case that Ashley Benefield, who was convicted, and then Marcia Thompson, who was acquitted, they both relied on battered spouse syndrome defense. And the point of bringing them up in that motion isn't to argue what they were acquitted or convicted of. It was to say that state of Florida, where they were being prosecuted, the judges granted both of them bond. So they're arguing that same initial charges, same probable defense, Courtney should be granted bond. So, but yeah, so they want to make this CGI video of the one Paraiso apartment that Courtney was living in to demonstrate while she's explaining what was happening that afternoon, how there was movement away from like the hallway area and the table where the Subway sandwiches were, like this, there's like a table and there's like a long kitchen island. And her claim is that she threw a knife from 10 feet away because she was scared. So that's going to be, they want us to be able to visualize what was going down.
Before we go through the expenses of finalizing the actual video itself.
So I guess what I would want to have happen is if you have a general idea or an example of something that has been created in some other civil litigation.
Yeah, no, absolutely, Judge. The company, and I'm sorry to cut you off.
Yeah, no, that's because I would need to say, okay, what do we even air in front of me?
The company is 3D Forensics. They have a 100% admissibility rate as far as being able to show they've never been denied. And we have samples of what they've done and the resume of the engineers that developed this technology and whatnot. So yes, we have all of that we can provide.
I think that would be something.
Certainly helpful, Judge, but the hard part about it is if this comes down, especially for demonstrative purposes, a decision by the court. And it'll come down to the prejudicial effect of what this video actually shows. So,
So in general terms, if you provided an example of something that had been used in a similar litigation, which I'm sure, you didn't just come up with this out of thin air. Obviously, this exists, right? So I would need to see that type of an example. Then I think you would have to explain to both Mr. Adcock and the court how you see and envision that playing out in reference to Ms. Clenney's case.
Sure.
That way then I could rule on a legal matter to say, okay, so yes, no, or a different
Right.
route, and then create the actual video for a final ruling at some point.
Right, absolutely. I think it's going to be subject to a final ruling and testimony by the experts as far as how the court's going to rule on that. But yeah, Judge, they've done everything from civil litigation, reenactment, vehicle collisions for personal injury cases to act with police shootings. It's all based on video, and then being able to get measurable points of reference, and then they do their fancy engineering stuff to it.
Which is what the problem could be, right? The fancy engineering.
Well, what this is, which is why this is, well, it's not different, but they use the raw data from the Faro scans that were done at the apartment to produce.
Sorry. I was just saying we're going to get penthouse daddies instead of crash daddies in this case. That's all I was saying.
Scene.
Got it.
So that part clearly is
Dancing around
can't be
in
contested.
I'm sorry, I didn't speak over you.
That's okay.
We're way far ahead of ourselves at this point.
Sure.
I think that I won't require necessarily the state to file a response unless we're able to provide some sort of examples of how this would play out. So that one,
We can
that
table
to
that.
me is, yeah, that's way
Yes.
in the, not distant future, but in the future.
Yes.
What about the motion for reconsideration of bond, which I agree with Mr. Prieto would probably be something we would do as a threshold matter? Are you going to file a response?
I am, Judge. That's the next one I'm going to work on. So this is a third request of the defense for a bond. First, was the Arthur hearing. Then there was another hearing for reconsideration based off of a medical examiner listed as well as a knife throwing expert. And now there is a secondary witness, which has not been listed yet, is the grounds for this one. So the only issue with my response is they have provided this person's report. I don't know if they intend to list this person or intend to actually use them, but I do need to depose them. So it's hard to say, outside of just writing off of their report, what it is that I would respond to. So.
Mr. Prieto?
Yeah, Judge, I don't see why the state would need to depose this expert witness. It's an expert medical examiner from Hillsborough County that in the collateral civil case testified to matters pertinent to basic arguments that were made at the Arthur hearing by the state. The state
It was actually really interesting in the motion for bond reconsideration. This is, when they're saying the civil action, this is the case initiated by Christian Obumseli's estate. And they're going after Clenney, they're going after the One Paraiso building management and the security staff, not going after first responders. But this medical examiner testified over in that proceeding, and now the defense, Courtney Clenney's team, wants to introduce it here to counteract the state's argument that Courtney acted with a depraved mind. That after she threw the knife or stabbed him, because the state's theory is a close-up stabbing. They're disputing the defense's theory of the knife flinging from 10 feet away. She stabbed him, and then called her mom and just dilly-dallied before calling 911 and let him bleed out. So, cold, ill will, depraved mind. But this expert, this medical doctor that testified in the civil action, the defense wants to bring him in for the purpose of this bond hearing because he said it was an imminent death. That type of injury, a slice to the subclavian artery, was going to cause imminent death. There was nothing that anybody could do to save him. So time didn't even matter. So now they're going to introduce that as a way to argue for bond.
argument at the Arthur hearing, quite honestly, and it wasn't Mr. Aberhoff, but a timeline where in the state's mind, right, as charging this as a manslaughter, the depraved mind, charges a second, right, the depraved mind aspect of which was the third element of what the state has to prove for answer. They claimed that Ms. Clenney allowed the the alleged victim in this case to bleed out basically 13 to 14 minutes prior to calling 911. This expert, the defense's argument was no, she called 911 right away. The phone records show, right, that she called 911 at this, anyway, I'm getting into the minutiae.
Is there a transcript of the testimony that this witness gave at a prior proceeding?
There is, in the collateral civil matter,
Okay.
there absolutely is.
And is that something that you could provide to the state?
It would cost me
Expensive.
on the leg, but sure, I could order his
Yeah.
deposition.
I mean, I think that at some point in the future, they're going to want to depose this person, but if you're relying on, and I'm not saying that it has to happen before the motion for reconsideration of bond, don't get me wrong, but what I'm saying is, in order for the state to be able to respond, because that is one of the bases that you have put forth, then he needs to know what this person is going to say.
Right, I attached a very detailed expert report as an exhibit to the motion, where Dr. Webb's, Malad Webb, details his findings, the basis of his findings. He refers to all the sources that he used to find it. All those opinions are contained in that expert report.
Okay,
So that's been provided to the state.
all right. How long do you need to file a response?
So again, Judge, so it depends on this trial. If this trial goes on Monday, I anticipate the trial will be finished Thursday or Friday. We have a probation hearing that I don't think is going to go on Friday. It should flee out. So in theory, I can start working on this either Friday or the following Monday.
Okay.
But I need to depose him. If I am provided this deposition, I don't need to depose him. I know what he's going to testify to. So the problem is a report is going to be a summary of what this person believes in.
I'm not going to have that. I'm not going to delay it for a deposition for you to be able to respond. I think you can respond on what you have.
Okay.
And Judge, I did speak to Mr. Appelhoff, and I told him what the gist of the report, and obviously look at yourself. This medical examiner determines, based on his review of an expert, I believe qualifies as an expert, but he says that the injury occurred more likely than not, to his degree of medical certainty, that Ms. Clenney called 911 immediately after the injury.
Okay. Let me ask you this, Mr. Creator. When you talk about the fact that you want to prioritize the motion for reconsideration of bond, which I agree, is that something that you are asking this court to do before we take a 2-week break during the holidays? In other words, does that have to happen before the 19th of December, or could it happen the week of January 5th?
Judge, I have to defer to the court, and Mr. Appelhoff is entitled to respond, so I'll defer to the court and the state on this. I mean, but obviously, there's a long history here of delay for a lot of reasons.
I'm just talking for scheduling purposes, because
I will make myself available
Okay.
on the earliest date possible.
Okay, Mr.
If we can set it for the 19th, Judge. The 18th.
I have literally said everything in this division for the 19th, and we're also supposed to host a little gathering for the staff after calendar. So why don't we do the 18th? I want your response done by the 16th at 5 p.m. And we will set the motion for reconsideration on 12/18. Let me just take a look and make sure that that's not going to be problematic.
She's happy about that. She's happy about that because it's another shot at potentially getting bond before the holidays.
All right, so what about the motion for bill of particulars? Does the state
Judge.
have a response on that?
That 16th,
Okay. Everything.
well, the 16th, that one will be either handled or responded to.
Okay, bill of particulars by 12/16 at 5 p.m.
Oh,
All right, and the motion to suppress.
So Judge, this was previously,
for anybody that's not looking at the screen, anyone, doing your Saturday errands and just listening, they just zoomed in all the way on her nails, picking at her nails. Just straight
12/16
macro zoom.
p.m. All right, and the motion to suppress.
so Judge, this was previously litigated before the Arthur hearing, specifically only to the Arthur hearing. There was motions filed by the defense, the motion filed by the state. The defense's motion is very similar. I don't think it contains too many differences. I do intend to respond to it, but based off of the items that I think are taking precedent, I would ask that this be rolled over to the new year, and I'd be allowed to respond by maybe that first week of January.
I have no problem with that, Judge. I would just alert the state that this is an amended motion to suppress. We previously withdrew the motion to suppress simply because, although it's filed under a different rule of procedure, anyway, long story short is we amended it to specify the exact files as were provided to us in the start that we're seeking to suppress so that they have them. And I would just urge this prosecutor, because his prior colleague filed a response, made certain arguments. I would just ask this prosecutor to review those and see if he wants to adopt those.
We got the clear mug.
Sure he will. So the motion is
The judge wants us to know what she's drinking.
Review those and see if he wants to adopt those in his response.
I'm sure he will. So the motion to suppress response will be due by January 9th at 5 p.m. And
All
what
right.
about 404?
So I intend, honestly, we got a lot of it together for the Arthur hearing. There was one incident we were made aware of that occurred in Colorado.
Oh, the Aspen trip.
After the fact, we became aware of it. So it's going to take me not too much time to be able to put that together. The more important thing, though, Judge, is I don't want to list these incidents without actually having witnesses that will be available, or I know I'll be able to produce. So that's the amount of time I'm going to need. Is going to be more so collecting those witnesses. So I would request probably the middle of January for that.
Any objections to that, Mr. Bateman?
I would just ask that the state make their best efforts, because the designation of the 404 really impacts the manner in which we take their depositions. So now this is going to push those 404B witnesses, actually I think in the state's 404A, but it's going to now push us into February at the earliest. So I understand the state needs to research it. If they are relying on specific incidents, they need to gather police reports. If there are police reports, I think they're required to disclose that to us. So I know they've got some meat on the bone there, but I would just ask that they make, that's a hard deadline.
January 16th, 5 p.m.
And that's the witnesses, designating the witnesses plus any documentary evidence that they're required to provide under the rule.
That's correct. All right, I think that we are at 12 p.m.
Right.
Anything further from the state at this time?
Just to confirm, Judge, we want to litigate that motion to dismiss on that date as well? Or I'm not sure if defense wants to file a response.
Well, I know that Mr. Prieto wanted to prioritize the reconsideration of bond, but that's fine with me if everyone would be ready to do that on the 18th. We can do both the reconsideration of bond and the motion to dismiss.
Was there they already responded, so I need to review that. Do you think the court,
There's no rush on it.
we have enough time on the 18th to do that? I don't want to cram the court's calendar, because we can set that off in early January as well. Or the 18th, I mean, I'll be ready. If I think the state's ready, we'll be ready.
And what are we talking about, a couple hours?
I think at the most.
Well, Judge, the better question is going to be whether or not an evidentiary hearing is needed. I think
Right,
it's just argument. So I think, especially for
Let's do
the...
that, let's do both. Plan on the 18th.
Okay.
And then obviously you might get a ruling on the dismissal part, but.
Right, I understand. And as far as evidentiary-wise, there's already record evidence in the collateral proceeding that is sworn to testimony, and that was provided to the state.
I'm going to provide a copy to the court.
Yeah, no, I'll put together a binder for the judge, but But, yeah, I think that's right, and I don't, if I foresee some type of other live testimony being needed, we'll let everyone know.
Okay. Anything further, Mr. Adams?
No, Judge.
I think that's it, Judge.
Very good. I have a meeting that I need to
Yep,
catch.
absolutely.
Thank you all.
You got
All right, so nice and clean. So in addition to, like, we did a quick summary before we started watching the hearing because of what was on the docket. But now we hear that motion to suppress response, and it's surreptitious recording, sounded like videos, was due January 11th. So we'll look to see if that comes on the docket before then. And then the 404B stuff, we found out what that issue was. So it sounds like 404B evidence relating to Courtney Clenney, and they want to know what the state has. And I think what they might be getting at is the Colorado Aspen trip with the estate. So the civil lawsuit for Christian Obumseli's estate. This footage came out with Courtney Clenney. She was wearing like leggings and a crop top and I think a little blue bubble coat. And she's like hitting on Christian, and Christian's kind of like holding her, like his hands are making contact with her, but like more so to keep distance and restrain. That's what I think is the main thing that they haven't disclosed any witnesses. The individual who recorded that footage was, I think his name is Austin, was Courtney Clenney's like OnlyFans content influencer, one of the managers from her team. So they had subpoenaed him. I had grabbed all those records and we went over that. We did a deep dive on all of that stuff from Aspen. Let me get the link real quick if you guys want to check that out after this. But I'm wondering, there's been some TV production since then. You know, has the state gone and interviewed people? Have they turned over the interviews from individuals from different names of people that they learned after they came across this Aspen incident for the first time? And if so, is there anything that they've come across that they should be disclosing over to the defense? So that seems to be what the 404 issue was. And that Aspen incident was 2023. So 2022, excuse me. So it was right before the stabbing, the fatal stabbing took place. And the fight was over, like, I think the girl's name was Savannah. Courtney was yelling about Christian potentially liking Facebook pictures or Instagram pictures of another girl who was also on the trip. Good times. I don't advise doing that. Let's see. All right. So what I'm going to link to, let me open it up. It's a compilation of the videos, what I got from the discovery request, and some of the journal notes. So I took all of the discovery, like the evidentiary stuff.
Validated. Why does anything I say not matter?
It's old me on the screen.
It matters.
It just hurts me to hear.
No,
that.
shut up, shut up. When I talk it matters, I know what I tell God hears. God hears. And if y'all don't, it's fine. And what I say matters.
What you say matters, but saying that the people here don't like you is factually incorrect.
So that is the OnlyFans manager that's speaking. This was like an hour and 7 minutes deep diving into all of this. I think the video that went all around, can we see the blue bubble coat? I think this is the one that went all over the place.
Get the fuck off me.
You don't want to hit me?
Christian, if he saw me, and I know he's looking, I'm fucking like fed up with you. I'm fed up. I'm fed up with how you fucking treat me. Yes, I'm not mad at you.
You let Milan say some lying ass shit that affected you.
I didn't let her say anything. You fucking did it.
Hey, let's go to Milan right now. Let's pull up her.
No.
Oh, I think Milan was the name. Okay, Milan was the name of the girl. So I lined up all of the exhibits from that trip that were sent over. She even has some marks on her arm. She has her hand bandaged down here. Let me move this thing. Like, I was looking through all these pictures because, like, what is going on here? It's like she had a fight and then still had a shoot to do. And then her journal notes line up like describing fights that they were having at the same time. So these are text messages with the manager. And then all of these extractions are the Celebrite extraction with Courtney Clenney's notes application. So lining all of that up. Like here she is describing how this relationship took a toll on her February 2nd, 2022. So I highly recommend if you've missed that stuff and you're wondering like what I mean when I say, hey, this is not the type of trial I'm starting on day one of trial as if I'm a backseat juror with no outside context. This is what I mean when I say I'm too far into the evidence and I probably know way more than the jury is going to get to hear. So that's shaping my opinion. So definitely recommend checking that out. It is also in the description for Replay Crew if you want to go into this. It's called the Aspen Trip Deep Dive. So check that out. There's some other journal note video breakdowns in there as well. Troy Keisha's in the building. Good to see you. Also want to give a proper shout out to Sheriff Chuck. He had gifted during the hearing and we kept rolling through it, but proper thank you here to Sheriff Chuck for gifting 5. If you turned green, make sure you are saying thank you. And then Christy was like, I keep getting missed by these membership gifts, so I'm going to become a member. So thank you so much for supporting here, Christy. And there we go. Kate, good to see you. Kate, I feel like we always meet when there's Courtney Clenney content. And Kate says your videos are so helpful. I binge watched them. And it was a good time trying to go through these. Courtney's cell phone notes, like she really used this app as a diary. And it would go from like this long detailed fight of a description of a fight. And then the next note to herself would be like a grocery shopping list. And it would be like green beans, kale, frozen fruit. And then at the bottom, it would have content ideas for her OnlyFans, and it would be like bunny outfits and ripped tights. It was just like going through this. It was like, all right, here we go. When do you ever get to see a peek behind the blinders like this? So that's all we've got for the hearing, you guys, though. As you heard, the next hearing date, and that's going to be for bond and the motion to dismiss. But I think there might be a slight chance for bond. And again, more so because the state has caused delays in this case. It's been like 3 years that we've been waiting. Maybe she has a shot. Motion to dismiss, we'll hear the arguments. I don't think that that's gonna... I don't really see how they can argue a motion to dismiss when they're also going to give time on this bill of particulars for count 2. But who knows? And then we've got some responses that are due from the state. So I'll keep an eye on the docket for that. But plan on the 18th. I really imagine that there will be a live feed that day. That's a major hearing. So hopefully we can get together, see how that goes. And again, yeah, I know everyone's over these delays. Yeah, so December 18th we'll be back. Did I say the wrong date? These dates are hard to keep up with. Let me get the other me off the screen. Let's go to something random. Look at the countertop here. Or the hat store. Get the hat store. Yeah, we looked at everything from this Aspen trip. So, but yeah, there's so much going on in this case. Whatever happens between then, we'll go live and do a video if there's a motion. But I really think this 18th, unless it gets delayed, since it's a bond hearing, it'll kind of be like a miniature run of the trial. And it's a new judge. This will be the first time, I think, that Ricker, I always say her name wrong, Ricker Wolfson, will be presiding over a bond hearing. So maybe she's different than Sharon Cruz. So, Christy, a weird thing about her argument for bond, she's arguing that she will go be with her parents in Texas. She'll wear an ankle monitor. But I thought it was a bit weird that they didn't try to offer, in the alternative, we'll pay for, you know, the ankle monitor. We'll make sure she has someone here to supervise her here in Florida. It just seems like a big ask to say, let me go to another state. But for what it's worth, Texas had no problem shipping the parents over to Florida when there were warrants out for their arrest. So if you guys missed that saga, I don't think I linked that directly in the description of this video, but there is a link to my Courtney Clenney case update playlist. And if you want to go back there, you can see the body cam from the parents' arrest. So they take them from their Texas home, boot them off to Florida. So There we go, you guys. Where I wanted to redirect today is Miss Janet Demeanor, but her channel doesn't allow redirects. I'll have to tell her to turn that feature on. So let's see. And it looks like she may have ended her stream anyway. Oh, nope, she is still live. So I'm going to drop that link in the description. She is rewatching the Zachary Adams 2017 trial. But unfortunately, I can't carry us all over there. So you'll have to click that link in the description or search for Miss Janet Demeanor and find her channel. That being said, I might do a quick video on Tyrone Blackburn AI legal citation issues with LexisNexis, asking the court, asking Joe Tacopina's team to let the court know that what Tyrone Blackburn's saying about LexisNexis is not true. So I might do a quick video on that. And then tomorrow I might do some Zachary Adams stuff. Monday, Alicia Andrews sentencing. It's a Florida case. The sentencing is set to start at 8:30 a.m. So that's bright and early. If you live on like the West Coast, it's going to be super early. But I will be going live when the hearing starts. So bright and early, 8:30 Eastern, Monday morning for Alicia Andrews sentencing. Again, that is the Julio Fulio trial. She was acquitted of the top charges, but convicted of manslaughter. So we're going to see how Judge wants to lean with that. So hope to catch you guys then, or hope you can catch the replay for that. See you wherever. Bye, guys.